Hello, everyone. We will be waiting 1 more minute and then we will start. Thank you. Hi, my name is Natasha Neisman, and as a member of the DLA team, we would like to thank you all for your presence today. The theme of our webinar today is Understanding International Transfer of Personal Data, and we will have the presence of our LatAm IPT leadership alongside Carol and Hofer, co-chair, and EMEA Data Protection, Privacy and Security Group. Now, we will share with you some general instructions before we start. Please feel free to use the chat, but send the questions by the Q&A. We will answer the questions in the end of each presentation. We kindly ask you to indicate to each jurisdiction your question refers to. This event is being recorded and we will be publishing in our social media as in the YouTube channel. And now I pass the word to Ana Teresa Barreto, LatAm IPT co-leader. Thank you.
Thank you, Natasha. Hello, everyone. It is a pleasure for me to be with you today and to introduce you to part of the Latin America team of DLA Piper. In this opportunity, to the members of the Intellectual Property and Technology Practice Group, which is formed by professionals from Argentina, Brazil, Chile, Colombia, Mexico, Peru, and Puerto Rico. I would also like to thank Carol Hofer on behalf of all of us for joining us and sharing with us her knowledge and extensive experience in data protection issues and in particular in international transfers of personal data. DLA Piper, with presence in 7 Latin American countries, provides legal advice to domestic and foreign clients with interests throughout the region in an integrated manner in all countries. The teams in the different areas of specialization have in-depth knowledge of the jurisdictions and provide advice from a local and an international perspective with the resources provided by the DLA Piper global platform. The consulting capabilities of DLA Piper professionals in Latin America, together with the international experience, the integration, and the ability to expand practices to all jurisdictions, constitute a solid structure that provides to our clients great opportunities in countries where innovation and digital data and technology issues are constantly growing, like countries in Latin America. And therefore, in our countries, there are much field for development. In this opportunity, we will talk about international transfer of personal data in the European Union and in the Latin American countries, with emphasis in each of the Latin American countries where DLA Piper is present. We will start with each of our countries in alphabetical order, and we will talk about these issues and matters in our jurisdictions. And at the end, finally, we will have the participation of Carol that will share with us the transfers requirements. We will start with Guillermo Cabanelas, partner and responsible of the intellectual property and data protection area of DLA Piper Argentina. Guillermo, we hear you.
Yes. Hello. Thank you. Great pleasure to participate in this event. I will give a brief description of the Argentine personal data protection system and some of the problems it creates. The Argentine system is rather peculiar. It's relatively old. It has about 20 years, but its origins are rather different from those of other countries. There was a provision introduced in 1994 in the Argentine constitution, providing the right called of habeas data, the right to obtain information about one's personal data registered by other people. So the origin is rather different from what the law actually is nowadays, because it was, let's say, directed to a very specific problem, which was the problem of having access to what were called data banks, and especially data banks including credit information. Now, the interesting thing is that this origin, which is rather different from the origin of, let's say, of the European rules, resulted in legislation, but this legislation, to some extent, was based on the European rules at that time, and its interpretation and application has shifted more and more to be more similar to what is the normal, let's say, the normal standards internationally. So right now, the Argentine system is not radically different from, let's say, the European system. There are, however, certain differences that are worth mentioning. One difference is that the grounds to have access to and to process personal data are more oriented to consent of the personal data subject in comparison with other grounds that exist under European law. Another difference that should be mentioned is that you have to take into account not just the provisions of the personal data protection law, but also more general rules on privacy included in the relatively new civil and commercial code that we have. And also there are some isolated rules one has to take into account. For example, there are rules about pictures oddly enough, in the copyright law, which may create problems sometimes when you have access to personal data, or when you want to process personal data. The enforcement of the Argentine law has been rather weak. It has become stronger in recent years, in part because of the influence of comparative law. There is an increasing awareness that this is a matter which is of great interest for international, let's say, data transfers. So enforcement has become stronger, but it's still rather weak compared with other countries. There is a bill pending before Congress, which has a strong chance of being enacted, which to some extent reproduces the basic principles of the GDPR. I would say, fortunately, it's rather simpler than the GDPR. And there is a significant chance that this will be eventually passed because, let's say, the present Argentine law looks rather old, and eventually it will create problems for Argentina and its international transactions. One area I want to call attention to is the area of data exports, because that's where most of the practical problems arise. The general rule under Argentine law is that data exports require the consent of the data subject, with some exceptions. So one exception is when the export is made to countries which comply with the standards of Argentine law. And the Argentine authority issues from time to time a list of the countries that are considered to be valid recipients of data, of personal data, without requiring consent by the data subject. This includes most European countries, the European Union, and some other countries like Canada, Israel, Uruguay. Doesn't include the United States nor India. So that, from a practical problem, that is a major problem. The Argentine authority has provided, let's say, a mechanism to facilitate data exports to these countries that do not meet Argentine standards. And the mechanism is that it provides for a standard contract. And so if a standard contract is entered into by the person transferring the data from Argentina with the person receiving the data abroad, then the conditions provided by the law are considered to be complied with. Unfortunately, this standard contract is not very popular with multinational enterprises. It's a rather complex contract. So this solution provided by the Argentine authority is not much of a solution. And normally when transfer is made to countries that do not meet Argentine standards, the solution normally is to try to obtain a consent from the data subjects. So this is an area which has grown exponentially in the last years, and I think it will become even more interesting and of practical importance in the next years as Argentine law adjusts to more modern standards. Thank you, and now I give the word to my colleague from Brazil, Paula Mena Barreto.
Thank you, Guillermo. But before me, should I pass to Carol just for her to present the GDPR and everything in European community, because it's very close to Brazil. So I believe Carol could go before me.
Thanks, Paula. That was very interesting to hear from Guillermo about the standard contractual clauses in Argentina. Of course, the clauses that are best known are the EU, UK, the GDPR clauses. We're just going to revisit very quickly what the transfer requirements are under GDPR, under UK GDPR. There are really three principal mechanisms for transferring personal data outside of the EEA or the UK. The first one is on the basis of an adequacy decision, where the European Commission has recognized the laws of a country as being adequate in terms of protection of personal data. There are more and more countries with an adequacy decision. The Commission has really tried to bring more countries into the fold, so to speak. One of them, of course, is Argentina. They've had an adequacy decision for quite some time. There's a partial adequacy decision for Canada, for Japan, that's quite recent. South Korea got one at the beginning of the year. Israel, and of course the UK, Switzerland, there are other countries as well. So adequacy decision is really the easiest way to transfer because there are no specific transfer agreement requirements when you're transferring to an adequate country. After that, there are transfers made pursuant to contracts and other kind of binding terms. Those include binding corporate rules, BCRs. For those of you who don't know what they are, they're an internal contract, although they can have effect outside of the group, that bind the members of a group to certain protections for personal data. There are the European Commission approved standard contractual clauses. We'll talk about those a lot. I will talk about those a lot. Codes of conduct, there are none yet. Certification mechanisms. And then the third category are the derogations from all of the above, which, for example, include explicit consent from the data subject or a transfer that's necessary to perform a contract, certain type of contract, like when the data subject is a party to the contract. But the authorities tend to interpret these derogations extremely restrictively. So in most cases, you cannot rely on them comfortably. When it comes to the UK, which is now Brexited, the laws are still very similar to the EEA, but the UK has now issued its own standard contractual clauses called the International Data Transfer Agreement, the IDTA. It's a standalone agreement, but thankfully the UK has permitted the use of the EU clauses as long as you have a UK addendum to the EU clauses. So like I said, I'm going to be focusing on the standard contractual clauses. Why? Because overwhelmingly, they are the mechanism that is used for transfers outside of the EEA and the UK. Next slide, please. So the big news with the standard contractual clauses, of course, are the new clauses that were issued last year for the EEA and this year for the UK. They replaced the prior clauses. The prior clauses date from over 20 years ago, the first set, 2001, 2004, and 2010. They really needed updating, if nothing else, because of GDPR. They did not reflect GDPR. Obviously, GDPR took effect in 2018. So that's an important update. We'll talk about the details. And as I said, the UK now has its own clauses. In other words, their international data transfer agreement and the addendum there too. So one of the things to keep in mind is that those new clauses came with transition periods, so you didn't have to adopt them right away. Right now where we are is if you've got existing older agreements using the old clauses, those are in effect for the EU until December 27th. That's next month. So you've got about a month to essentially repaper and replace your old clauses for transfers outside of the EEA. For the UK, the deadline is March of 2024 to transition to the new UK clauses. So we're certainly seeing a lot of activity right now with clients who are accelerating their move to the new clauses in their existing contracts. So briefly speaking, how do the new clauses differ from the old clauses? Some of you will already know this, but it's a good reminder. There are twice as many options in terms of the data flows covered by the new clauses. So they cover not only controller-to-controller transfers and controller-to-processor transfers, but also processor-to-processor transfers and also processor-to-controller transfers. The clauses specifically allow for multi-party use, so you can have multiple parties to one set of clauses. This was a very common practice before, but the old clauses were drafted as if there were only two parties. So there's a little bit of facilitation in using the new clauses for multiple parties. Another thing that's really important, I'll get into this a little bit more later, is that the new clauses include the processor terms under GDPR. So most of, not all of you know this, but GDPR has very specific requirements for what needs to be in an agreement to bind a processor to a certain level of protection of the data it processes. So that those are, the Article 28 requirements. Those are included in the clauses. So the clause, for example, the controller to processor clauses, the processor to processor clauses. So it's kind of two in one. You get the processor terms plus the transfer clauses. And then these new clauses address Schrems 2, which, as everyone knows, was a decision of the Court of Justice of the European Union that was rendered in July of 2020. The principal consequence, at least from an America's perspective, was that Schrems 2 invalidated the United States Privacy Shield program, which was basically a partial adequacy decision. So that was invalidated by the court, but they did not invalidate the clauses. However, they said when using the clauses, it is necessary to assess the real risk of the laws of the destination country, which basically, instituted a firm requirement to assess transfers when using the clauses, also BCRs, to really assess those risks of the destination country laws, and then to determine whether or not what we call supplementary measures are also required, not just the clauses, but additional measures to protect the data in light of the laws of the destination country. So that is anticipated to some degree in the clauses which specifically require an assessment by the parties. Another requirement in the new clauses is that the importer needs to inform the exporter if a public authority requests disclosure of the transferred personal data. And there is an obligation on the part of the importer to challenge any request from a government authority, although there are some caveats to that obligation. So it's not an absolute obligation. Next slide. Okay, so practical implications of all this. Stepping back a little bit, one thing is from an EEA UK perspective, it is possible, even probable, that one organization is going to be relying on multiple mechanisms for transferring data outside of the EU or the UK. You might be relying on adequacy for some transfers. So for example, transfer to Japan. You will have SCCs in place for other transfers. You may have BCRs in place. Even if you haven't, as an organization, adopted BCRs, your vendor may have BCRs for processors and apply those obligations when processing your personal data. And then of course there are the derogations, which again are restrictively interpreted, but you might rely on them for one-off transfers, for example. So you've got these multiple legal approaches, and that's just for the EU and the UK. Another point I mentioned it, the fact that there are processor terms in the new clauses. In practice, what we're seeing, it's in some ways surprising, is that pretty much everyone is still using their old data processing addenda in addition to the clauses. So we now have a situation where there could be a conflict between the processing terms in the clauses and the processing terms in the DPA. I've seen very little movement in the market towards resolving these potential conflicts. So they will arise probably in the context of, say, a breach or a dispute. But it's something to be aware of. Preferably, there would be some kind of redrafting of a DPA to align it with the clauses if they are also in place with the data importer. Another thing we've been talking about a lot and we've been working on a lot is the enforcement of the Schrems II decision. So the decision that invalidated the Privacy Shield in the US. There have been a number of enforcement decisions. The Austrian authority, the French authority, the Italian authority, Norwegian authority, et cetera. They have interpreted the Schrems II decision very strictly, which raises a specter of a lot of transfers potentially not being compliant with GDPR. This has only pushed organizations further towards looking at limiting the data that they transfer outside of Europe, particularly to the US. Some cases we're seeing clients move data centers or certain data processing activities to the EU or the UK. And another thing we're seeing organizations do is expand their use of pseudonymization techniques and also encryption techniques in response to the enforcement of transfers by the EU authorities, basically saying that transfers to the US are illegal. One thing I would add, and I know that we're going to be talking about this at the end of the presentation, is that there is an executive order now from the Biden administration issued last month that is intended to support an adequacy decision for the US under a data protection framework that will support the, that will replace the data, the Privacy Shield. So we'll see how that goes. It needs to be approved by the European Commission, which we're hoping for next year. That would effectively mean there is, again, a certain level of adequacy for the US. One thing, and this is really, next bullet point, this is really important for this discussion today, is that the new SECs really create quite a few new obligations and compared to the old clauses. And so have really, in my view, moved away from the standards that were acceptable or still are acceptable in a lot of other countries. So in other words, we're seeing a widening gap in the obligations, under GDPR and the new clauses and a lot of the rest of the world. And not only that, but even outside of the LatAm region, there are a lot more countries adopting new data protection laws. And so they have transfer restrictions, and we're seeing more and more fragmentation of the requirements under data protection laws generally, but also for transfers. And really, one of the only ways to deal with this is to adopt internally, rationalized requirements. So some, I won't say approximation, but really, looking at the basic requirements of the laws most important to your organization and applying them everywhere within your global privacy program to try to align the requirements as much as possible. You might not get 100% compliant, but you'll get close to compliance. Hopefully, and we're happy to help you with that, of course. So I will stop there and hand it off to Paula, who is going to talk to us about Brazil, which is in many ways similar to GDPR, but yet different.
Yeah. So nice to see you all. And I would like to say like a few words just about, just give you a little of background about Brazil, because I don't know if everybody's familiar with the legislation, which is new. So we have a data protection law in force since 2020, which is a new law. And this law applies to all the processing activity performed in Brazil, or with the goal to provide services or goods to people located in Brazil, or data collected in Brazil. So we have a broad, like, how can I say, scenario here in relation to the application of the LGPD. So everything in these three scenarios will, the person and the companies will be subject to the LGPD. And what we have, and what is important that Carol mentioned, because our law is highly inspired by the GDPR. So we have like most of the definitions, principles, data protection rights. So we'll go through that. But what we have here in Brazil, our law is very new, and we do not have the culture education about data protection. So the companies are now understanding what the data are, what they can do with that in relation to international transfer, because most of the companies proceed with the international transfer, and everything now is more like the companies are more familiar with that. But the culture of our country is not in relation to data protection. So that's why it was a big movement. And that's why this law is still like, and we have like some issues, some interpretations that we need, because we have like some gray areas in this regard. And as we do not, although we do not have this culture, just for you to know that data protection right is a fundamental right now protected by our federal constitution. So it's something that is very relevant now in Brazil, and the companies must be aware with all the processing activity. And as I mentioned, what we have before entering the international transfer, just for you to know that we have like personal data, sensitive data, which is like the special category of data in relation to the GDPR. We have general principles. We have data subject rights. We have, how can I say, the position of the DPO that we also have in Brazil. And we also have a national authority, a local authority that will be handling all the issues and regulations in relation to data protection, and also to apply the penalties that we have in the law. So we have like our law, despite of some differences, we have like almost the same. And this could, the same of the GDPR, including the international transfer. So if you want to go to the next slide, we are going to the legal basis for the international transfer. So, and they are very similar to the GDPR. So in relation to the provisions and legal basis in relation to international transfer. So we also have the consent, we also have the adequate level of protection, binding corporate rules, the standard contractual clauses. So we have almost the same. I will not list here, but what it's important to say is that we have everything, but the local authority, our national authority, is still what? Regulating a lot of activities in relation to the law, specifically in relation to international transfer. Because we do not have like the SECs, the binding corporate rules, mechanisms, what we should do. We do not have like a certified country with adequate level of protection yet. So there are a lot of issues that the authority needs to regulate. This was part of the agenda. They are still like, they are in process of having that. First, it was like a prior consultation in relation what should they do in relation to international transfer. Then probably we'll have like a public consultation in relation to that. After that, they will issue all the standard forms and all the the rules and guidelines for an international transfer. And what is important here is that what we have the law, we have the principles, we have all the obligations for data controllers and everything, but we do not have, and we have the international transfer, because the international transfer of the companies are still going on. We have international transfer of data like every day in most of the companies. And I think like I can say like more than 90% of the companies in Brazil. And what we should do in relation to this gray area. And just one point that is important to say that Carol was mentioning, different from the GDPR, we do not have like the obligation to have an agreement with the processor. Actually, we have a lot of liabilities in relation to the controllers. So it's highly recommended to have like an agreement with all the other controllers or processors, but we not have like a express obligation of that. But still, it's important to have a DPA, a data protection agreement in place with the third parties in relation to the sharing of data. And in our opinion, what should companies do in this situation? Because I believe in a practical way, and we hear a lot about that, but not in a practical situation, what we should do. And because as we believe that the obligations are there, you have like as a company, as a control liability in relation to the data sharing, in relation to sending the data to another country. And an observation here is that why the international transfer is so important in the defense and why the local laws and everything is so like getting attention to that. Because if you are transferring data, the other country, if it's not adequate and the level of protection is not the same, what you can have if you not have like the same rules and contractual rules in that country, the data, you will not protect the data subject, which is the main goal of our law, is to protect the data subject. So if you are transferring, that's why we believe that even if in this gray area in Brazil, we have to follow and to adapt for having like an agreement with the third party in relation to international transfer, the SECs, and as we do not have the lack of structures here in Brazil, we believe that we can use the standard form of other countries, such as the European Union, because as there are a lot of international countries that are already using that, we believe that's possible, and that is good to apply not the entire SECs, because sometimes it will not like apply to Brazil because there are differences, but we believe that this may reflect in the SECs from the data from Brazil to other countries. So we believe that we should use the SECs approved in other countries, for instance, the European Union, in order to comply that, of course, having in mind that you should be aware that, and you should have a clause, a provision saying that after like the issuance of new regulation or standard form in the local, by the local authority in Brazil, these must be replaced, these must be automatically replaced in order to avoid any doubt and to comply with the regulation and also with the law. These are my main comments in relation to international transfer, and I would love to hear all the other jurisdictions. And I'm going to George now from Chile. If you could talk a little bit about Chile.
Thank you, Maria Paula, and thank you all for having me here. Nice to see you all. Well, in Chile, it's probably in process of becoming something like Brazil. Our current data protection legislation is more than 20 years old. It's law on the protection of privacy. And I will talk about a new bill that it's being discussed in Congress, but now what is currently applicable in Chile is this law that's more than 20 years old, as I said, that it doesn't specifically regulate international transfer of data. So there are no specific requirements and no special rules regarding international data transfers. And therefore, the only thing applicable is generally applicable rules to any processing of data, as international data transfers are not anything else under the Chilean law than a data or data processing, as would be a local data processing fee. That means that in Chile, according to this law, generally speaking, any data processing requires consent, which makes it pretty hard to get sometimes, except for a few exceptions, in which the law provides that the consent is understood to be given even if there is no express or specific consent. So the main idea here is that under the current Chilean law, there are no specific rules on international data transfers, and only general rules apply. Next slide, please. So focusing in the data protection bill, which is being discussed in Congress for several years now, which we expect to be enforced hopefully by the beginning of next year. It is expected to be passed by Congress in the way it is. It's been amended and modified several times since the discussion began in Congress. And it, I would say, tends to follow the GDPR principles in most of it. It will contain, I would say, one big novelty is that we will now have a personal data protection agency, which we don't as of this point. It will also specifically regulate international data transfers in what concerns this webinar. And I would say it's pretty similar to GDPR and other more modern regulations like Brazil, for instance. So in general terms, international data transfer under the bill, when it becomes a law, will be permissible to countries with adequate levels of protection. In this case, which countries will be adequate will be determined by this new data protection agency. It will be, I mean, it's decisive whether the country meets similar or higher data protection standards. So what we expect at the end of the day is that this new data protection agency should probably recognize countries that are also recognized by the EU, at least in the first instance. It will also be permissible to have international data transfers in which or when there is a particular contract or other legal instruments that establish rights and guarantees of data subjects and obligations of data controllers and the means of control. Next slide, please. Then other permissible international data transfers will be those in which the receiving controllers adopt binding and certified compliance, self-control, self-regulations, express consent, of course, as it is today, specific banking, financial, stock exchange transfers, in which or when they are carried out in accordance with laws that regulates those transfers. In this particular point, one specific thing that has been a new development in Chile is that we now have a fintech law, which regulates data processing for fintechs. And it's in line with GDPR and it's in line with the bill. So that's why we wouldn't expect the bill on new data protection to be changed in a bigger way than it has been the several years that it's been discussed in Congress. Then this letter F here in the slide, it's an authorization to international data transfers that are made between companies in the same business group when they operate under the same standards and policies regarding the processing of personal data. And then you have when the transfer is necessary for the conclusion or execution of contracts. So as a general rule in Chile now, again, we do not have specific rules on international data transfers. They're all subject to the general regulation and so on. You will probably need express consent to make the transfer. What we expect is this will change probably early next year, hopefully early next year when the new bill comes into force. And what should companies be doing? And we're doing it now with some of our clients, is anticipating what should look like a big, or I would say difficult task in terms of conducting data protection audits, identify target countries of international data transfers, and work from that in order to reach probably GDPR standards, as they look very, very similar to what our new bill will look like. So happy to help anyone that needs some help here in Chile to audit their data protection processing and implement new standards to comply with the new law. And now may I pass this on to Maria Claudia from Colombia.
Thank you, Jorge. I'm Maria Claudia Martinez. I'm partner at DLA Piper Colombia, and I lead the data protection practice here. Well, regarding Colombia, it's important to mention that, as we have heard from the different jurisdictions, it's based on practically the same principles. Yes. Here we have a regulation since 2012 that specifically regulates data protection in general. It's a data protection regime here in Colombia, but this is issued because in 1991, the Constitution considers that there's the data, habeas data right, is a fundamental right, as Paula also mentioned that happens for Brazil. But it was not until 2012 that this general regulation was issued. And through Law 1581 and Decree 1377 of 2013, data transfers and data transmissions were regulated, like data transmissions and data transfers abroad, right? So we have that new regulation, and this year, the government issued a decree saying that the Superintendence of Industry and Commerce, which is the data protection authority here in Colombia, must issue a regulation regarding the acceptance of corporate binding rules for intra-group transfers. So it's important to mention that right now, even though this decree gives like the general rules regarding corporate binding rules, this has not been regulated by the Superintendence of Industry and Commerce, so it's not in place yet. Which means that for intra-group transfers, we have to comply, sorry, with the general regime for data transfers between third parties. Okay, so it's important to understand that, as it happens like in other jurisdictions, there's a difference between a transfer and transmission. And in Colombia, this difference also has an impact on the prohibition or not prohibition of moving data abroad. So an international data transfer is considered a transfer between a data controller or a data processor abroad, right, to another data controller. And the difference with data transmission is that the person that receives the data abroad is not responsible of the data. It's not a data controller, but it's a data processor. So that's the difference. The thing is that in Colombia, cross-border data transfers are prohibited to jurisdictions that provide adequate data privacy standards. On the other hand, the transmissions abroad are not expressly prohibited. You just have to comply with different statements. So to understand which jurisdictions provide inadequate data privacy standards, the Superintendents of Industry and Commerce, please next slide, is in charge of establishing which are the minimum standards that the other jurisdictions have to comply with for it to be understood as adequate. It has these different requirements that you see in the slide. Basically, it's the same regime that applies for Colombia: the existence of the same rights, the existence of a data protection regime, the rights of the data of the individuals, the duties for a data controller and data processors, and the existence of a data protection authority. This is what applies for Colombia. So what the SIC said, if the other jurisdiction has this minimum standards, we can consider it as a jurisdiction with adequate standards, and you can transfer data to those jurisdictions. Up to date, the list of countries on your right in the slide are the ones that have been recognized by the Superintendents of Industry and Commerce as jurisdictions that have adequate standards for data privacy. And so you can transfer data, personal data, to those jurisdictions. Next slide, please. But what happens if the jurisdiction you want to transfer data to is not in that list? So you can ask for a declaration of conformity to the SIC. That's what the law says, yes? The SIC has issued soft law saying that effectively people can ask for a declaration of conformity, saying that for a specific purpose, one data controller can transfer data to another data controller abroad, even if it's not in those jurisdictions that were listed before. And this declaration of conformity, the SIC would say, okay, for this purpose, this specific time, you can transfer data to that jurisdiction. The other thing that obviously this is a process that has to be filed before the Data Protection Authority, and so it takes time. This is why through soft law, the SIC also said, okay, if you consider that the jurisdiction you're going to transfer the data to, even if it's not listed in the jurisdictions that I have already said have adequate levels of protection, you can transfer it to that jurisdiction if you consider that that country complies with all the requirements that we mentioned are needed for to consider it an adequate standards for privacy. And this can be evidenced or proved after sending the data abroad through the accountability obligation of companies to have everything in compliance with a local regulation. I mentioned this, and I am really specific saying that it's soft law. This is not what the law says, but for now, this is what is the SIC has considered until now. So you can transfer data to another jurisdiction different from the ones listed before in the last slide when you ask for a declaration of conformity, or you consider that that jurisdiction actually complies with all the requirements for it to be considered an adequate minimum standard levels. Okay, but the law also states, and the decree also states that this prohibition doesn't apply if, as we have all mentioned in all jurisdictions, you have the consent of the individual, right? If you have the express consent of the individual to transfer the data abroad, there's no problem. You don't need the jurisdiction to be in the list of the minimum adequacy levels, or and if it's not listed, you don't need the declaration of conformity. If the individual accepts its data to be transferred to another jurisdiction, you comply. There's no prohibition there. Also, there's another list of data transfers that can be done without the prohibition. Well, the prohibition doesn't apply, and it's when there's medical treatments that have to be done for bank and stock transfers because of an international treaty in which Colombia is party, and when it's needed for a performance of an agreement, which is really curious from my point of view, and when it's needed for the safeguard of public interest. So that's the regulation we have in Colombia for data transfers. Regarding data transmissions, the law states that you need the consent of the individual for these transmissions. If you want to send data abroad for a processor to process the data or treat the data on your behalf, you need the consent of the individual. This consent is not needed when there's a data transmission agreement in place that complies with minimum requirements the law states, which is basically that they protect the habeas data of the individuals, and they're going to comply with a Colombian regulation regarding data privacy. So if these data transmission agreements are in place and comply with these minimum standards, you can transmit data abroad with no consent of the individual. That's actually what we have for Colombia. And so I will pass a word to Gabriela from Mexico.
Thank you, Maria Claudia. Good morning, everyone. My name is Gabriela Laña, and I'm the head of the data protection practice here in the DLA Piper Mexico City office. So no surprise, in Mexico, there are some similarities in some concepts in other LatAm countries. In Mexico, the data protection is also a constitutional right. And here, the legal framework is comprised mainly by the federal law on protection of personal data held by private parties. This law was enacted in 2010. Its rules and regulations were enacted in 2011. And from there was some, for example, privacy notice guidelines, recommendations on personal data security, parameters of self-regulation regarding personal data. There is a general law in connection with personal data processing, but in possession of obligated subjects. The obligated subjects are mainly governmental, entities, which is not the subject matter of this discussion today, but I just wanted to mention because there is a specific regulation, specific legal framework in connection with processing of personal data backed by the government. And there are some other guidelines and recommendations issued by the Data Protection Authority that it's aimed to make easier to understand all the rules and regulations and terms and conditions that govern data protection in Mexico. Next slide, please. So what is a transfer in Mexico? A transfer is a communication of personal data with or within or outside the Mexican territory between the controller and a third party. And this third party must not be a processor, because if that is the case, then we are talking about a remittance rather than a transfer, which it's governed by different rules. So we are going to focus now on transfers in which the communication is made to a third party, that it's not a processor or not someone processing, this personal data on behalf of the controller or pursuant to its instructions. So in Mexico, international transfers are allowed as long as certain requirements are met. And as we will see, they are very specific. The first one is to notify the data subject in the privacy notice that the transfer may be made, to whom this personal data will be transferred to, and for what purposes. And I say that it's a more, specific because in this case, the privacy notice must include even the name of those parties, those third parties to whom the data is going to be transferred. If it's not possible to have the specific names, then at least a reference to the type of entities that we are talking about should be included, such as marketing companies or insurance companies or universities, in order for the data subject to make a decision and to consent or refuse the transfer. The privacy notice must include a clause whereby the data subject expressly says whether he or she consents or refuses the transfer. Unless, of course, this consent is not required. We'll see in a minute when the consent is not required. The second requirement is that the purpose of the transfer must be limited to the purpose and conditions informed in the privacy notice and consented by the data subject as applicable. This is important because, the transfer should not have a purpose that goes beyond the purpose that was notified in the privacy notice. And this is important because the data subject needs to feel and to be protected and to know exactly for what purposes her data will be transferred to a third party abroad. The personal data recipient, the third party abroad, must assume the same obligations to which the controller is subject to. And why is that? Because, an international transfer is made. The third party does not assume automatically the role of a controller because of the territorial applicability of Mexican law would not go beyond, beyond our boundaries in that sense, because the third party is unrelated to the controller, unrelated to the data subject, and therefore this information must be protected somehow. And the only way to do that is that the third party assumes exactly the same obligations to which the controller is subject to. How is that formalized? Unlike some other LatAm countries, in Mexico, it's absolutely necessary that the controller and the third party abroad document this transfer and establishes expressly the terms and conditions pursuant to which the transfer is made. The law is somehow flexible in the sense that this formalization or this document can be, through contractual clauses or other legal instruments that must include the same obligations that the controller is subject to. It must include somehow a notification to the third party informing the purposes that were informed or included in the privacy notice, so that the third party abroad knows exactly those purposes that in principle should be aligned with the purposes that are going to be for which the information is going to be used. Unlike in Europe, there is no specific format of clauses or agreements. Now the law is broad enough to say whatever or however you want to do it, but you have to have these clauses or instrument in order for the third party to be aware that it's going to be bound by the same obligations. It's important to note that in case there is any changes in this the scope of the transfers or changes in the third parties to whom the transfer can be made, then the controller must notify the data subject, because if there is any change, then that change or the transfer that goes beyond whatever was included in the privacy notice, then it will not be protected. And if that is the case, then the controller may be subject to imposition of fines by the Data Protection Authority in Mexico. Like some other countries, there are some cases in which the consent it's not required by the data subject in order to make an international transfer. Next slide, please. So when the consent from the data subject is not required? Well, when there is a law or a treaty to which Mexico is a party allowing to make the transfer without this type of consent. When it's necessary for medical diagnosis or prevention or healthcare of the data subject. The consent is not required when the communication of the personal data is made among holding companies, subsidiaries, or affiliates that are under the control of the data controller, or there is apparent because there is a rule and there is the obligation to be subject to the same type of data protection policies and internal restrictions and limitations on this. Also, the consent is not necessary when there is a contract executed or to be executed between the data controller located in Mexico and a third party, but in the interest of the data subject. Why is that? Well, because again, if there is an agreement and a document establishing the terms and conditions pursuant to which the information will be protected, then we will be fine. And also because somehow the consent of the data subject it's granted because there will be an agreement between those two party controller and third party, but in the benefit of the data subject. Also, it's not required when the consent when the transfer is required to safeguard public interest or for the administration of justice. In this case, of course, there should be a kind of a formal request by the judicial authority asking for this type of information. Also, in cases of recognition, exercise, or defense of a right in a judicial proceeding, and also when it's necessary to maintain or comply with an obligation resulting from a legal relationship between the data controller and the data subject. So as you can see, those are, somehow very specific requirements that we saw in slide 2, and that this is because the law wants to protect is one is the confidentiality of the information. 2, that the data subject is informed of the fact that a transfer will be made, and most importantly, because the authority wants to be sure that the data subject right to agree or refuse a transfer is fully respected. Okay, so these are the rules for Mexico, and in case the audience has any questions or inquiries in connection with this, we will be happy to help you out. I'm sorry. Now we turn to Daniel Flores in Peru.
Thanks, Gabriela. Hello, everyone. Glad to be here. I'm Daniel Flores from DLA Piper, Peru. Well, just for clarity, some relevant background information to consider when we talk about data protection legislation in Peru. First, Peru has had a personal data protection regime since 2011, year in which the Peruvian Personal Data Protection Law was enacted and the National Data Protection Authority was created, which is the Directorate for the Protection of Personal Data, a body attached to the Peruvian Ministry of Justice and Human Rights. Then in March 2013, the regulation of the law was published in order to develop clarify and expand on the requirements of the law and set forth specific rules, terms, and provisions regarding data protection. Both the law and its regulation came into full effectiveness in May 2015. Regarding the scope of application, the Peruvian data protection legislation applies when data processing is carried out in an establishment located in Peruvian territory, when data processing is carried out by a data processor, regardless of its location, on behalf of a data controller established in Peruvian territory, when data controller or data processor are not established in Peruvian territory, but the law is applicable to them by contractual provisions or international law, and when the data controller is not established in Peruvian territory, but it uses means located in Peru for processing of personal data, unless such means are used only for transit purposes that do not involve processing. Now, regarding international transfer of personal data, according to the Peruvian law, transfers may be permissibly made when the country afford adequate protection levels. That means protections that are equivalent to those afforded by the Peruvian law or similar international standards, as GDPR, for example. But if the receiving country does not meet these standards, the sender must ensure that the personal data will be processed according to the standards set by the Peruvian law. And the way to do that is ensuring that the receiver is contractually obligated to provide adequate protection levels. Through a written agreement, which include that the personal data will be protected in accordance with the requirements of the Peruvian law. And this is actually related to the standard contractual clauses that I will talk about in a moment. In the case of Brazil, Chile, Colombia, and Mexico, in Peru, we also have, next slide, please. Thank you. We also have exceptions for the transfer. So the transfer of personal data is also permissible if a country does not meet adequate standards under the following, circumstances. In accordance with international treaties in which Peru is a party, for purposes of international judicial cooperation or international cooperation among intelligence agencies to combat terrorism, drug trafficking, money laundering, corruption, human trafficking, and other forms of organized crime, when necessary for a contractual relationship with the data subject or for a scientific or professional relationship. Bank or stock transfers concerning transactions in accordance with the applicable law, when transfer is performed to protect, prevent, diagnose, or medically or surgically treat the data subject, and when the data subject has given its prior informed, express, and unequivocal consent to the transfer of data. Also, regarding transfer of personal data, recipients must be required to handle such data in accordance with the provisions of the Peruvian law and its regulation, and assume the same obligations as the transfer of the personal data. Also, the transfer must be formalized by being a written contract capable of demonstrating the obligation of the recipients. Next slide, please. Okay. However, personal data is transferred from Peru to any country, the data controller must inform the authority about the cross-border transfer of personal data. Further, data subjects also must be duly informed about the conditions regarding transferring of their personal data, which must include the recipient identification, the recipient location, which is the country, and the purpose of the transfer. And as you will remember, just a few minutes ago, I mentioned that if the receiving country does not meet the security standards, the sender must ensure that the personal data will be processed according to the Peruvian law. So the transfer must be formalized by a written contract. It is in that sense that the Peruvian authority just approved, like a couple of weeks ago, and for the first time, standard contractual clauses for international transfer of personal data. The purpose of these clauses is to guarantee and facilitate the compliance with the mechanisms provided by the Peruvian law for the execution of a cross-border flow to a country that does not have an adequate level of personal data protection in their legislation. Therefore, through the clauses, the authority has made tools available to the public for compliance with provisions of the law and its regulation to ensure the appropriate personal data protection when the data is transferred to a country that does not have an adequate level of personal data protection. So far, only two types of standard clauses have been approved. One that is applicable to the transfer of data from a data controller to another data controller, and another applicable to the transfer of data from a data controller to a data processor. Of course, it is expected that the authority issues further decisions for a better interpretation and use of the recently incorporated standard clauses, as well as approve all those standard classes, for example, for transfer of data from a data processor to another data processor. Finally, at the moment, the clauses approved are provided just as a guideline. Okay, so they are not binding. It's like soft law at the moment. I think that's all from me. Thank you very much. And now I pass the word to Mariana Muniz Lara from Puerto Rico.
Thank you, Daniel, and good afternoon, everyone. In Puerto Rico, the most important thing is that there is no specific regulation on international transfer of data, but we have some local legislation related to consumer data protection. It's mostly framed in relation to privacy policies and data breach. There is also a general regulation that is administered by the Department of Consumer Affairs that says that entities must take all necessary measures to protect the privacy, confidentiality, and integrity of personal information that consumers provide to entities. There have been several bills for legislation that are based in the GDPR and the California CCPA, but they have not passed, so we still don't have a general data privacy regulation in Puerto Rico. But the Puerto Rico Supreme Court has determined that an individual's personal information is protected by the Puerto Rico Constitution under the right of privacy. It's important to note that in Puerto Rico, the right of privacy operates against everyone, not only against the government. So anyone can bring a lawsuit regarding their data and if it has been mistreated or misused. So there's always a risk of exposure to a claim in that area. There is also a bill in the federal government. As you know, Puerto Rico is a U.S. territory. So there's a federal bill for the American Data Privacy and Data Protection Act. It was proposed recently in June 2022. So if that bill is passed, it will apply to Puerto Rico. So even though we don't have a set regulation or guidelines for data transfers, we usually follow the practice that the US follows. And in the US, generally, there is no geographic transfer restrictions, but there may be some exceptions related to national security. What we usually recommend is that entities provide a notice for a general consent for the use and disclosure of the information and the transfer to other countries. It's going to be a very general consent.
So maybe it will not be upheld in many countries, but we always recommend that. And also we are recommending the use of pseudonymization and encryption, and they are being employed. Also for very sensitive personal information like health information, financial and biometric information, there must be technical, physical, and organizational measures that protect the security of the information. And our final recommendation, similar to what Paula mentioned, is that entities review all the different policies in the different countries, and they determine which one has the highest standards, and they follow that one, because then they can have a uniform policy, and they will be complying with all the different countries and regulations. I also wanted to mention, I think Carol already talked a little bit about this. It's in the next slide. The next slide is there are many transfer issues for U.S. companies that conduct businesses in the European Union since the Schrems II ruling in 2020. Carol already discussed this, but I wanted to mention that there is an executive order, very recent, of October 2022, that is designed to enhance what was the privacy shield before. And if this is finally executed, then companies will be able to have those guidelines. Now we will go to Carol for the Q&A session.
Thank you very much. So just a couple thoughts before we move to the questions and answers. It's very interesting. We're seeing a bit of a trend towards standard clauses. We've had them in Argentina for a while. Guillermo was telling us about that. Daniel was telling us about the clauses that have been adopted now in Peru. Even though they're not mandatory, they might facilitate transfers. I see always standard clauses as facilitating transfers because they take some guesswork out of what needs to go in the contract. But overall, what we see is that, you know, consent still has a very important role in transfers outside of the country. And so this goes to one of the questions we received, which is very interesting, because a lot of times what we're talking about are transfers of employee data. And for those of you who are familiar with GDPR and the directive before it, there is really a hostility towards employee consent, because it is felt that employees cannot usually freely consent to anything that their employer asks them. And therefore, it's unusual that we would ever rely, you know, from a GDPR point of view, on employee consent for any type of processing, let alone a transfer. So the question I have for all of our panelists is, you know, how is employee consent specifically seen in your countries? Is there any indication that the law or the interpretation of the law might be moving towards a GDPR position where consent will no longer be valid if it's coming from an employee and is given to an employer? So I'm going to start, well, alphabetical order. If Guillermo, you can respond to that question first.
Yes, well, surprisingly, I must say that Argentina, the answer is that there is no tendency to limit employee consent, which is considered as just part of the general case. It may be that in the future that changes, but not yet.
Great, Paula?
You know, for Brazil, I think it's the same in comparison to the GDPR, because here in Brazil, the consent must be free. And because of the imbalanced relationship with the employees and employer, we believe the consent will not be the best solution, with some exceptions, but not like a mandatory consent is not like allowed. here a pre-checked consent or something it's like something that you were obliged to do. Although an exception of the consent that it's really free for the employees, is something that they can choose or not. But if this is something that in relation to the regular day by day, and it's necessary, the consent, because of the flow of the data and everything, these will not be valid in Brazil. And I believe, I believe I can end here.
George?
Sorry. I would say in Chile, the employee consent would be valid, at least for now. Maybe under the new law that would change if the new agency tends to interpret that it is not voluntary, but as for now, it is totally valid.
Okay. Maria Claudia? What about for Colombia?
In Colombia, it is completely necessary, the employee's consent to the employer. And mostly if the data is going to be used for different purposes than just the relationship between the employee and employer. For example, to send an invitation for the employer's Christmas party, where specifically those consents is like completely needed. But for Colombia, for now, this doesn't tend to change. The privacy clause in the employee's agreement has to be included for the data to be treated. On the other hand, regarding the specific question regarding Colombia, well, as I mentioned, there's a exception of the prohibition to transfer data abroad when it's needed for the execution of an employee agreement. This is important to consider, that this exception is when it's needed for the execution of the employment agreement agreed between the employee, that is the data subject, and the data controller, the employer, as data controller. So it is important, you can apply this exception and say that you don't need the consent of the employee to transfer data abroad, for example, to transfer it to the owner of the Colombian entity. Yes, that they need to have the information of the employees in Colombia, but you really need to know why this is necessary for the execution of the employee contract, right? If you have the argument, you can apply the exception. If you don't have that argument, or it's really just because the owner of the Colombian entity just wants to have the information of the employees, but it's not really necessary for the execution of the employment contract, well, maybe you're not under that exception, right? So the best way to go is just to ask for the employee's consent.
Got it. Great. On to Gabriela for Mexico.
Well, in Mexico, Carl, is the same story. Employees' consent is absolutely necessary. I don't foresee this to change because on the contrary, if there will be some kind of proposal to get rid of employees' consent, it would create, a high criticism, because then it would be deemed or understood as, denying the employee's right to provide her consent for its data, personal data to be processed. So there is, I don't see a way that it would change in Mexico.
Okay, thank you. Daniel, what about for Peru?
Well, in Peru, the employer does not need the employee consent if the data is strictly necessary to perform and the execution of the contractual relationship between the parties. However, if the data is going to be used for other purposes, something that it is not strictly necessary, consent is necessary and would be valid. but only if it is freely given by the employee, and that includes no, negative implications for the employee if decide not to give it.
Great. And Puerto Rico, what's the view from there on consent?
Yes, in Puerto Rico, employers provide employees a disclosure of how the information is going to be used and processed. And after they are informed, it is understood that they have given an implied consent.
One thing that is important, Carrie, because I don't know if in other jurisdictions and if we have time, but the consent, at least under the Brazilian law, can be deleted or can be withdrawn. So it's something that it's free, and sometimes it's not, even if it's accepted, which is not the case here because it's not free consent in relation to mandatory consent, but sometimes it's not good to have the consent, because the consent, you must be aware, because if the data subject does not provide that, you may not, you can't transfer or you can't process the data that they are deleting or they are like withdrawing.
Good point. Thank you, Paula. We probably have time for one more question. Interesting question. I'm going to open the floor. Is the U.S. in all jurisdictions considered an adequate country for the transfer of personal data? So for those jurisdictions where this is relevant, would the U.S. be termed deemed adequate?
I can start if you agree, Carol.
Yes, please.
Thank you. Well, in Colombia, the U.S. does have the adequate levels, but when this was being analyzed by the SIC, they were actually going to say that the U.S. did not have adequate levels, but it was really because of a political and transactional economic reason that they decided to say it was okay to transfer data to the US. But that's like to have the story clear. So the US is adequate for Colombia, but when the SIC was studying and analyzing, they were going to say that it didn't have the adequate levels.
Very interesting. Anyone else like to respond to that question?
Just for Brazil, just saying that we do not have like adequate country yet. So
yes. Do you know whether the U.S. will be deemed adequate, or is there any indication that it will?
If I know if it will, I don't know. Actually, I believe not, because it's a different, very different, and could have the same problems as you have in the European Union. So.
In Mexico, we don't have this adequacy issue, Carol.
Okay, great. Anyone else?
Yeah, in Argentina, it's considered not to be adequate, and it's unlikely it will change in the near future.
All right, that aligns, of course, with the European Union for now.
Yeah.
Same in Chile, I would say when we have adequacy, it should probably not be included in the list.
Okay.
Well, in our case, we don't have a list of exhaustive list about countries with adequate measures, but actually the authority, for our authority, the U.S. is an adequate country because they said that in a legal opinion that issued a few months ago.
Okay. Mariana, I think I know the answer.
In Puerto Rico, yes, the U.S. is adequate because we are a U.S. territory.
Yeah, absolutely. Okay. Well, that's it. We're actually at the end of our webinar. Thank you very much, everyone, for joining us today. Thank you, especially to our panelists, and to Natasha for getting us off to a good start here today. As you may have seen, we will be making the slides available, and the recording will be available on our YouTube channel. Thank you very much. We hope to see you again at another LatAm series webinar in the near future. Goodbye.
Thank you. Bye-bye.
Goodbye. Thank you very much.
Thank you. Goodbye.